Case set for argument is Medina County Prosecutor's Office versus Mr. Cox. It's case number 18CA0081M, and both parties are represented by counsel. So each of you will have 15 minutes to present your arguments to the court. The appellant can reserve up to 5 minutes for rebuttal.
I would like to do that, Your Honor.
You want to reserve the whole 5?
Yes, please.
Okay, I'll let you know as you get close to that time.
Okay.
Okay, the court has read the briefs in this matter, and we are prepared to proceed if you are, sir.
Thank you, Your Honor. Counsel, may it please the court, I'm W. Jeffrey Moore on behalf of Mr. Cox. I want to look at the reasons why the court said that by clear and convincing evidence, the state proved that the money was contraband in this case. The first reason being Mr. Cox's explanation of the purpose of his travel are contradicted by his appearance. Mr. Cox said that he was going to see some lady he met on a line or something like this and go out with her for food. Now, maybe you and I and a lot of people dress up pretty nicely to do this, but I'm sure that there's somebody with a greasy shirt somewhere taking some lady out for food. So I don't know that this means that this money was contraband. I don't even see how it's relevant. Nextly, 2 canine alerts, one on the vehicle, one on the cash itself. There is testimony that the suitcase in the trunk had marijuana shake. This is akin to what marijuana shake is like what's on the carpet in your car. There was nothing they could salvage to charge my client with. They never charged him with anything. They didn't even charge him with the speeding they pulled him over for. The other said that there was marijuana, the dog hit on the cash. There's plenty of cases that say that dogs hitting on cash does not mean that cash is contraband. It's well known that the currency in the United States has a lot of drugs on it or around it or smells like it.
Well, you can't produce any evidence of that, right?
I can't, but I can also say that I've read cases that say that that's why it's not considered in a forfeiture action. Your Honors, there was a large, number 3, a large amount of cash, $22,300, was packaged in 3 separate bundles in the suitcase. Okay, there was marijuana shake in there. That doesn't mean, that could have been, who knows, personal use, whatever, I don't know. But that doesn't prove that that money was contraband.
But when you add all those factors together and look at the totality of the circumstances.
I don't think anyone's relevant other than maybe the money was in the suitcase with marijuana shake. That might have some relevance.
Well, the dogs did alert to it.
Well, of course they would. It's marijuana shake. I don't have any problem.
And to the
money.
To the money.
But their case law says that dogs alerting to money is not to be considered.
I understand your argument. What I'm saying is when you put those things together, which you're allowed to do, there's marijuana shake, there's $22,000 in 3 different bundles, the dog alerts to the drugs and in the car and on the money.
If I'm not mistaken, I put in my brief a case which was even more shocking, which had, I think, a gram or 2 of heroin and a gram or 2 of cocaine and the money. And they said that that was not indicative to prove that the money was contraband and had been produced from some illegal source. The next, number 4, was that marijuana was found in the suitcase with the cash. We've already gone over that, I guess. And then there was an overwhelming odor of raw marijuana found in the suitcase with the cash. Well, there was marijuana in there, marijuana shake. That doesn't prove that the cash came from illegal sources or was contraband.
Counsel, what are we to do with the evidence of the prior record, since this is a civil forfeiture proceeding?
Well, Your Honors, I'm pretty sure that we don't allow legal bad acts into evidence for the purposes of proving that the person acted in conformity thereof at this time.
For good reason?
Yes.
Yes.
So that's all that really does, doesn't it?
Well, but this is a civil forfeiture. It's an interesting legal question, is it not, in terms of...
It is, other than I don't know why the rules of evidence say it's not relevant, but we're going to consider it in a civil forfeiture, which I thought contained the rules of evidence in proceeding. I could be wrong, but. Please, ask away.
Well, I guess the question is the interplay of the constitutional rights in a criminal proceeding as applied to a civil proceeding when you're just dealing with things like hearsay and rules of evidence in that respect.
Well, I think the prior bad acts evidence applies in this case too.
Okay.
So it wasn't presented like that, that's all I'm telling the court. Nor was it evidently considered, although I'm sure it was. Then we come to number 6, and this raises a number of issues. Mr. Cox gave a myriad of incredible conflicting accounts of the origin of in his comments to Trooper Baker and his interview with Sergeant Helton. Okay, that's the first part of that. I present a case on my brief. It's not my client's burden to say that this is prove that this wasn't contraband. It's the state's burden to prove it was. And there were several cases that I put in there that it doesn't matter what his explanation is. It matters what the explanation is from the state as to how this is contraband. Now, I did put in there, and the state says I didn't raise the issue, that some of these statements came from what I considered being a legal arrest. I did question the trooper on that extensively. You'll see that in pages 46 through maybe 54 in the court record. I questioned him as to why he, for possessing that cash and nothing else, took this man from the scene in handcuffs to an outpost, evidently, that they used to talk to DEA people without having a reason to have arrested him. Now, this goes further than just a brief detention for a speeding ticket. And I raised that. And I don't believe that anything said to the DEA agent should be used. But then again, I also don't believe that it's our burden to prove it isn't. And he has to offer an explanation for it. The state has to prove the money came from illegal sources. And they haven't done it. The other issue in number 6 is that the court says some of the accounts, like receiving checks or income tax statements, could be readily verified by documentation that was not offered by Cox. This, to me, stinks of shifting the burden to my client. He didn't have to offer anything where the money came from. Why was that important? He had no duty to offer that. They had to prove, by clear and convincing evidence, the money was contraband. He didn't have to prove it wasn't. Again.
But counsel, I'm sorry for interrupting, but I
Yes.
didn't get in here with a question. But the case law does provide that the court can consider the defendant's explanations.
That's true, but not his lack of an explanation, which that says.
Well, he gave several explanations as
But
to why he
this,
had
Your
the
Honor,
money.
with all due respect, this says, some of the accounts, like receiving checks or income tax returns, could be verified by documentation that was not offered. My client didn't have that burden. So why the court considered that, I don't know.
Well, I think that might go into his credibility.
Okay, but he didn't have a burden to produce anything.
But case law provides that you can look at explanations that the defendant gave. If he didn't give an explanation, he wouldn't have any burden to provide anything, that's for sure.
Well, Your Honor, in my brief, let me find this if I can. Let's hope I can.
Counsel, I don't want to get you off your train of thought if you.
That's okay. I believe the case of Marmot Drug Task Force versus Paz states that the main focus here is how the money is proceeds from drug trafficking, not the flaws in the possessor's explanation of how we got it. That's a quote from that case. Finally, in number 6, Your Honors, it says, Mr. Cox at one point told police he acquired the money from shooting dice, which the court accepts as an admission of acquiring money through illegal gambling. The officer stated that there was just a little bit of money that was explained that was through gambling. However, they proceeded on a trafficking issue. We still have notice pleadings, and they did not say the money came from illegal gambling. The case was based on trafficking, not legal gambling. It's our contention that the state did not meet its burden, it did not prove by clear and convincing evidence that this money was contraband or was from illegal sources, and that it should be returned to our client.
So counsel, you're saying the state alleged that in their notice of forfeiture, then they said that this was, this money was ill-gotten through
Trafficking, yes.
They specifically said that.
Specifically, not gambling. Thank you.
Thank you, you'll have your full 5 minutes.
Thank you.
Mr. Lang, on behalf of the county, 15 minutes.
Counsel, if it please the court, thank you. I will take the issues raised in appeal in the order that they were stated. First, I believe that the first issue was the issue of suppression of evidence. And that issue was not properly raised at the trial court. There was no motion to suppress evidence, so there was no hearing on that issue. Therefore, I think...
Why would you need to file a motion to suppress evidence in a civil case? That's what I was trying to figure out whenever I was reading that.
And I would, in this case, in the appeal, the issue was raised as whether the evidence should be suppressed. In the context of that allegation of error, and I think this is an issue that I struggled with in evaluating how to proceed in a civil forfeiture case, the interplay between the criminal procedure and the civil. So it appears to me that if the issue of suppression of evidence is even available in a civil proceeding, and that would be the first question, because this is a civil proceeding, does the suppression of evidence rule apply? If it does, I think it's incumbent upon the defendant to raise that as a specific issue at the trial level, and I think the cases support that. So that issue has been raised on appeal, and I think the cases are clear, even in the context of a civil forfeiture, that if suppression of evidence is raised, it needs to be raised in the form of a motion to suppress evidence and a specific hearing on that issue, so that a targeted hearing to consider the issues of suppression. And that was not done. So there was no hearing that was targeted on the issue of suppression, no motion made to suppress, therefore the issue has been waived. Nevertheless, even under those circumstances, there would have to be plain error for the Court of Appeals to even consider that issue. I think if you look at the facts in this case, it would not support that kind of extraordinary review of the issue of suppression. So I don't believe that they should prevail on the issue of suppression of that evidence. The next issue was raised was the allegation that the court had improperly shifted the burden of proof to Mr. Cox. I think that that is a mischaracterization of what the court did, based upon a singular statement in the order. That statement was an observation as to the evidence that the court made, that there was an opportunity to present clarifying evidence, but that opportunity was not taken.
Was the state's theory that this money was proceeds or an instrumentality?
Well, I think that the statute would allow for forfeiture on either, and we did not specifically plead either one. I think the evidence, I think, could support either, and the court chose to, in its finding, to say it was the proceeds. Now, I think there was just as good an argument that it was intended to be used, which the statute also contemplates, that this money was held to be used to traffic in drugs. So our argument was not limited to either one. It took advantage of entire scope of the statute. Back to the issue of the shifting of the burden of proof, I don't believe that that is a valid argument. I think the court made its decision based upon an appropriate standard of proof. So the final issue, which may be the primary issue on this appeal, is whether the trial court abused its discretion based on the evidence. I think it's clear that the court used the correct standard of clear and convincing evidence and stated that. That was an issue that was raised at the trial level as to whether the preponderance of the evidence or clear and convincing evidence would apply. The court chose the clear and convincing evidence, which is the higher standard, so there really is no issue on that. The case law, as was pointed out earlier, is directed to consider a variety of factors in a case like this. Whether the money was in small denominations, I'm quoting from the Katz case, whether drugs or drug paraphernalia were found with the money, where the money was found, the amount of money found, how the money was packaged, possessor's employment status, the owner's explanation for the cash, are all relevant factors to consider. At the trial, the state of Ohio presented a great deal of evidence demonstrating that the $22,300 found in Mr. Cox's trunk was the proceeds of a criminal offense. Mr. Cox was in a rented car, which drug couriers often use because they blend in, or newer vehicles don't break down and do not belong to the person driving the vehicle, so that they can't be seized. Mr. Cox was coming from one drug hub, Columbus, to another, Akron. Trooper Baker stated that he dealt with drugs moving along I-71 corridor on numerous occasions. Mr. Cox's story seemed rehearsed until Trooper Baker caught a hole in his story with the dirty clothes and the first date explanation. Mr. Cox had numerous felony drug convictions on his record and was on federal probation at the time. Trooper Baker's canine alerted to the odor of narcotics by scratching the left rear wheel of the well area. Upon conducting their probable cause search, they found a suitcase in the trunk. Opening the suitcase, the trooper smelled an overwhelming odor of raw marijuana. And the suitcase contained marijuana shake and 3 separate bundles of U.S. currency totaling $22,300. A subsequent canine sniff of the currency in postal boxes mixed with other items confirmed the alert on the currency. And in that test, they used general currency in the other boxes. So it wasn't, if the notion that all currency has some odor of drugs applies, well then there was a control of that test. And then there was a great deal of conflicting evidence from Mr. Baker, Mr. Cox himself, regarding the source of this money. At trial, he testified that he had no recollection of the suitcase. Some of the money, he testified some of the money had been given to him by an individual he could not name. Some of the money came from gambling on the streets. Some of the money came from income tax returns. Mr. Cox told Trooper Baker he had picked up the money at 2 residences that morning. So he did not possess that money until that morning, by his own explanation to Trooper Baker. And he was carrying that money in a suitcase that he also picked up that morning, which he didn't even remember at the time of the trial. So there's a significant amount of inconsistency in his statements. The case law indicating that his explanation where the money came from is relevant evidence. And then finally, the court makes an observation that Mr. Cox hasn't had an opportunity to clarify that evidence. He could have clarified his own statements by presenting evidence, but he did not. He chose not to do that. That does not constitute a shifting of the burden of proof. That's simply an observation regarding the nature of the evidence that was submitted.
What about the fact that the court talks about that he admitted basically engaging in illegal conduct and by gambling? I mean, because the state they're saying in your notice of forfeiture, you claimed it was through drug trafficking.
Yes, and I would say that that portion of the court's order, I don't take to mean that that is the basis of the forfeiture. I think that is a comment on the evidence itself, which is to suggest that he has not come forward with evidence that demonstrates a legitimate ownership of the money. So I would not interpret that as the basis of the forfeiture, but simply a finding with regard to the explanation of the source of the money, which counters the notion that this is his money legitimately held. And I think the court, I don't think it's correct to interpret the court's decision as that being the basis of the forfeiture. For all of those reasons, the State of Ohio respectfully requests that the Honorable Court affirm the judgment of the trial court.
Okay, thank you. And Attorney Moore, you've got 5 minutes.
Thank you, Your Honor. First of all, let's work on what we were talking about the gambling. That was not a comment on the evidence. It states, the court has considered the following factors in this case, which in their totality produce a firm belief that on February 12, 2017, Cox possessed U.S. currency, which was proceeds or instrumentality of a criminal offense or offenses. Number 6 says gambling. Now that also says it's a factor that the court considered. That was not pled in their case. Nextly, the court considered the fact that allegedly, or I guess it considered, that the person was coming from a hub city of drugs to a hub city of drugs in a rental car. So if I rent a car in Columbus and I drive up to Akron and they pull me over, that means I'm suspicious? I never knew Akron was a big hub city for drug dealing. Chicago might be, and I don't think Columbus is. So that's sort of nonsense. Also, I wonder whether they pulled the person over if he was white for the same reasoning. Nextly, constitutionality exists in civil cases as well, and the state provided no statements or no cases to show that suppression had to be raised in any sort of way in the trial. I have no idea. I don't think you can file a criminal suppression motion in a civil case. I raised the issue. I'll let the court consider for what good it is. Nextly, this case was decided on inference after inference after innuendo after innuendo. Not once can they prove, the police officer or the trooper even said so. Do you have any direct evidence or witnesses to show this was contraband? No. Do you have any direct evidence or witnesses to show this was gotten from drug trafficking? No. Do you have any evidence or witnesses to show that this was going to be spent for drugs? No. Now that's the trooper's statement. Everything else here is nothing but hearsay, innuendo, and inference on an inference. We hope you'll return the money to my client. Thank you very much.
Thank you both for your arguments. The court will take this matter under advisement as well, issue a decision in due course. On the day the decision is released, the clerk of courts will mail each of you a copy, and you can also check the Supreme Court of Ohio's website where the opinions are posted.
Thank you,
Thank you for your arguments.
Thank you.